Ladies and gentlemen, welcome to the Bullpen. He's back in the Bullpen today. We have former officer and noted commentator on things law enforcement and social, Mr. Brandon Tatum. Mr. Tatum, good day.
Thank you for having me.
Thank you for being back. So we're going to chop it up about the new indictments. You have multiple indictments from the Department of Justice in relation to the murder and also scheme to cover up Breonna Taylor. I don't want to presume what you know or feel about this particular Department of Justice prosecution or theory of their indictment. So if you would provide us with your sentiment, and I would then opine.
Yeah, I think that the entire indictment, in my personal opinion, seems like a witch hunt to me. However, there was a detective and an officer that appeared to have lied about information on the search warrant. They should be brought to justice. They should go to jail. But there's two other individuals that are on this indictment that have no relation to the search warrant. They have no relation, or at least the lies that were spoken about on the search warrant. They have no relation to it. Brett Hankinson was already acquitted of the exact same charge that they're charging him with on a federal level. And also the sergeant that's involved in this that I believe is not gonna be found guilty is another individual that I think that they engrafted into this to bolster their case and to create or continue what I would consider to be a witch hunt.
So let me correct you on one dynamic, dear brother. The officer that you just referenced who has been charged by the state crime and acquitted is not charged with that crime federally. He was charged with wanton endangerment by way of Daniel Cameron, the attorney general, black male Republican, who said he actually put in danger the neighbors of Miss Taylor. He was indicted for that wanton endangerment, which is a rarely used statute on the state books, and was found not guilty. So when you say that the federal government charged him with the same thing, the federal government does not have a wanton endangerment statute on the federal code. Are you aware of that?
Well, I think that you're mincing words. It's
How?
Relatively, to me, it's relatively the same thing. It's relatively the same thing. They're trying to portray that he was negligent in the shooting that he was involved in. And that's the same thing that they attempted to prosecute him on in I would argue, a more liberal state case. And then now they're trying to reactivate it on the federal level. I'm just saying, based on my knowledge in law enforcement and based on my knowledge of justice, he's not gonna be found guilty in federal court. This is a waste of time. They're trying to engraft as many officers as they can to bolster their case. They got two people that are clearly appear to be in the wrong and they should be prosecuted.
Now that's really interesting. So I'm gonna deal with your statement about the wanton endangerment in a moment. They're not the same, it's not the same charge, and it's not even the same theory. I will explain that to you in just a moment. You called this a witch hunt in the beginning of your commentary. And then you proceeded to say, however, 50% of the cops who have been arrested, all right, they should be arrested. You still stand by that. So that's not a witch hunt. You're saying that two of the cops that have been charged, they should have been charged based on the information that you have.
Well, let me explain. Let me explain what I'm saying by this. It's because when I say a witch hunt, I mean that they're engrafting more officers in to bolster a case. If they really wanted these individuals charged, they could have been charged on a state level. Or if you charge them on a federal level, just charge the two people that are involved in the crime in which you're pursuing, and not try to add as many officers as you can, which is gonna weaken the case, and people are gonna be more upset because only probably two of these officers are gonna be indicted or at least being found guilty. I believe one of them already pled guilty. So this is just another element that I believe the federal government is wasting taxpayer dollars on. They could go after the two individuals that they believe they have probable cause for, and the other two individuals they're trying to stack it to bolster their case, which is, in my opinion, a witch hunt.
So let's go through the elements here. You are a former member of law enforcement, so you do have an understanding of the law. Two individuals decided to engage not only in prerequisite false information, which is a violation of oath of office. They lied on affidavits, provided false testimony. They also engaged in the cover up. So afterwards, when they met, decided to conspire in order to cover up the initial crime of faking the documentation to obtain the warrant. So that's one indictment. That indictment covers the cops who were involved in the paperwork prerequisite that led to the death of Breonna Taylor. The second indictment charges Detective Hankinson, as you mentioned, with the civil rights offense for firing his service weapon into the apartment. Now, here's the dynamic that I think you're missing. In the original state charge, the wanton endangerment was about reckless conduct and how that reckless conduct created a safety issue for those around Breonna Taylor and her then boyfriend. The scope of this federal indictment talks about the reckless conduct directly at Miss Taylor. As an officer, let me ask you this. Have you ever, without verifying the identity and without a known threat, have you ever or known someone, one of your colleagues perhaps, that fired into an apartment, a house, a window that had curtains and knew not who they were firing upon? Has that ever happened to you?
It's never happened to me. Let me bring this to light too. Is everybody that's involved in this is presumed innocent until proven guilty. I just want to make the statement that it appears that they have probable cause to make the arrest that they've made, at least on 2 of them. I just want to make sure that's clear because people.
Well, that's clear,
they may
but
not
I would
be
like
found
you to
guilty
answer my question.
They may not be found guilty, but I'll answer your second question about the behaviors that Brett Hankinson displayed was cleared already. They had determined that his actions were at least reasonable in the scope of his explanation.
That is
now,
incorrect.
Could it have endangered people? The answer would be it could have, but was it negligent? Did he have the intent to go and shoot through blinds to willfully shoot at a person that he could not see? That's not what happened.
You're incorrect on the law here, Mr. Tatum. I would encourage you to go and research the law.
Well,
the law does not require.
If I'm incorrect on the law, correct me exactly what you're speaking about because I read it. I read the indictment. I read the original case. I made videos about it.
Well, if you read the indictment, you would have read that this was not an issue of intent, but an issue of.
In the indictment, it says that his behavior and his intent led him to fire shots that were unjustified, knowingly presenting a danger to the public, presenting danger to other people that are in the apartment complex.
Sir,
given
I'm
the
going to
fact
try.
that he was shooting into the residence.
All right, Mr. Tatum, I only have a few minutes to correct the error. So the more you talk, the more errors I have to correct. So first, the indictment does not charge that the officer intentionally tried to commit murder. That's why the officer is not actually charged with murder. Do you understand that?
It's not murder because he never shot Breonna. That's
okay.
The reason why it's
not murder. Do you understand there is no attempt to murder? There is no murder dynamic, and the reason is because there is no intent. You have to prove the intent element for murder to stick. So,
Dr. Richey, you're
not
understanding the justice system. They don't have nothing to charge him with. You're the one don't understand, dear brother. I'm trying to be patient with you and educate you, but give me about 60 seconds. I think I can do it within that time and give you the opportunity to respond. So the officer, because of his negligence, known or should have known that firing inside of an apartment that he could not see and firing through a curtain and window that he cannot see through would create an absolute danger to a citizen in this country. That's why I asked you specifically, have you ever done that before? Have you known any of your colleagues to do that before? And you have told me no, which means you know it's criminal. Your colleagues know it's criminal. It's not true.
Have you? So you've never done it. You don't know any other cop that has done it. Well, this cop did it. And you're saying it's not criminally negligent.
When Hankinson did it, was he found guilty in a court of law?
Sir, he was charged with wanton endangerment of a neighbor. He was never charged.
So was his actions endangering anybody?
Sir,
according to the charge.
This is very simple. All right, let me take you back to elementary school. The officer in question has never been charged with the crime in relationship to Breonna Taylor, number one. Number two, the federal government has concurrent jurisdiction to investigate and to prosecute crimes in the United States of America. They decided to charge this cop with the absolute negligence created and with the shooting inside of her apartment, not knowing or establishing the target whatsoever. You have already admitted this is not normative behavior. You've never done it. Your colleagues have never done it.
I said that I've never done it. I don't know any person that have done something specific like that. But clearly, there's articulable reasons why he did the shooting in the way in which he did it. Because they charged him.
What the hell are you talking about?
Not guilty.
Brother? So let's go back to the original charge of wanton endangerment, since you want to keep it there. You are aware that it doesn't matter if he was found guilty or not guilty of that particular element of a crime external of Miss Taylor, external of Miss Taylor's apartment, that has no bearing on the Department of Justice willing to take a charge or willing to allocate a charge or grand jury serving a charge up as it relates to her apartment. You do understand the difference here with the jurisdictions, right?
What I'm telling you is that he's not gonna be found guilty because there's already a case that was tried. And you gotta think of how they tried.
That has nothing to do
he was tried,
with the new case that is being brought.
Liberal peers that are not favorable to him. On a federal level, they're gonna draw from peers that are a lot more favorable to Brett Hankinson in his original trial.
So this isn't about guilt or innocent. This is about some jury members being favorable to him.
It will be. I'm just telling you.
But that's what you're saying. You're not saying this is about his guilt or innocence.
You're trying to create
arguments. No, sir. You just said this was about a jury being favorable to him.
What I'm saying, listen, this is how the justice system works. They're gonna draw from a particular jury pool, right? And the jury pool was incredibly liberal. More than likely, they were not.
Are you aware of the jury pool this federal government?
You're going to draw from more conservative, liberal, conservative.
I don't even know where you get that from. The jury pool,
and I guarantee you, he's not going to get charged.
Well, sir, he's already charged.
I mean, he's not going to get found. He's not going to be found guilty.
Okay. So you do realize that the jury pool has expanded because of the jurisdiction of the federal government. It's not a limited jury pool, it's more of an expanded jury pool. And before I go, brother, I just want to ask you this question.
Which makes it different.
Really quick question.
You expand from Kentucky as a whole. It's more favorable.
Is it wrong, sir, is it wrong for a police officer to shoot inside of an apartment without having eyes on the target and shooting through windows that are closed and doors they cannot see through? Is that right or wrong?
It depends.
No shots being fired, no established contact with the target, no weapons, no threats, no nothing.
Contact with the target.
Sir, is that legal or illegal?
In the doorway.
Is that legal or illegal?
He identified the target in the doorway. He moved his position to the window, which he knew in a general area where he was shooting at, and he was found not guilty.
The target was drugs and money.
No, it wasn't.
Did you know that? Sir, in the warrant they signed, the target was drugs and money, which by the way, they found zero.
Well, you see, this is why people like me are doing what I do. Breonna Taylor was the original target. There's a person on the warrant, and then there's a warrant for search. She was shot. He was her boyfriend was sitting in the house for about 15 minutes before they ever came in to rescue Breonna.
Sir.
There was a potential that they could have flushed drugs and all kinds of other different things.
A young woman who was innocent or not?
Say that again.
Did they murder a young woman who was innocent? Should be alive today?
No, I don't see it that way. I see it that she was killed.
Why did they cover it up?
It was unfortunate.
Why did they cover it up?
It's not. You see, you're
admit it.
Cover up.
Why did they cover it up, brother?
There's not a they covered it up. There's two different elements here.
Why did they cover it up?
The warrant. There's people who executed the warrant who actually shot her.
You're not going to answer the question.
And then there's people who were drafting the warrant that had nothing to do with the execution of the warrant.
We'll bring you back when I have more time. I got another show I got to get to. Thank you so much. I appreciate you. Thank you.